Hey, it's Dr. Tom Nacella with Strategic Chiropractor and StrategicDC.com, and today I'd like to talk to you about a landmark case for chiropractors fighting for their rights. If you do PI work, you may want to forward this information onto attorneys that you work with, as it could prove helpful in future MVA cases. Here's why. A recent case in the New Jersey Supreme Court ruled that expert witnesses who testify in medical liability lawsuits must be in the same specialty as the defendant. In Nicholas versus Meinster, the court agreed that the physicians who do not practice in the same specialty should not testify as expert witnesses. This has big potential for chiropractors. Here's why. While chiropractors are rarely subject to medical liability lawsuits, the potential impact of this court case is the heart of the matter at question, which is this: the establishment of a standard of care. And as you know, standard of care, or an outside expert witness's interpretation of what is the standard of care, what is reasonable treatment, or what is medically necessary, is a major obstacle that we routinely face as chiropractors. Whether it's an IME cutting off your care, a paper reviewer who decides that your treatment was unnecessary, or an auditor demanding money back, standard of care is at stake in much of what we do. So back to the case and its potential to apply to what we do as chiropractors. Who decides the standard of care? Here's what the court case had to say. Since the liability issue invariably is whether there has been a breach of standard of care for the medical specialty of the defendant physician on trial, the information comes best from someone practicing in the same field. That's what the associations argued. And the plaintiff in this case was Edward Nicholas. He was treated for carbon monoxide poisoning at a hospital emergency room in 2005. The MD, Christopher Meinster, was a board-certified emergency medical physician, and he treated Nicholas with 100% face mask oxygen and recommended his admission to the hospital. The plaintiff suffered a brain seizure, and he and his wife filed a liability lawsuit. To support their case, they supplied the testimony of a Utah physician who was certified in internal medicine, critical care medicine, and pulmonary diseases regarding the standard of care. The witness testified then that hyperbaric oxygen should have been used instead of the 100% face mask oxygen. Here's where it gets interesting. Although an expert in hyperbaric medicine, the witness was not board certified in either of the specialties of the defendants. As such, the New Jersey Supreme Court then pointed to the state's Patients First Act and ruled that lawsuits must abide by the law's requirement that expert testimony must come from a physician in the same specialty as the defendant. So here's the potential impact for chiropractors. Beyond medical or product liability, the obvious victory in this case is that a doctor should have right to someone in his own specialty to review the case. And it's no secret in chiropractic that the vast majority of medical reviewers employed by payers, whether it's a PI payer, a commercial payer, or even Medicare, they're not chiropractors. Typically, they're nurses, occasionally internists, GPs, or other physicians. And this recent case may change this fact and require that chiropractors review chiropractic claims. Furthermore, many of us have faced witnesses in PI cases who are anything but experts in chiropractic. Again, thank New Jersey for great potential here to remove that. Now, some states already have in every category of provider or similar laws which put chiropractors on equal footing or requires these type of things to have the same specialty defendants. And this is great because instead of a higher ranking, so to speak, physician ruling over little guys, it should be apples to apples. So in this, we need to remember to fight for our right. You know, there was a silly song in the 80s that proclaimed fighting for your right to party. Well, that may not be the noblest of goals, and nor is it one that maybe most mature adults would stake their life on. But Beastie Boys anthem aside, even if you're not chumming with lawyers and you have a jaded view of our political system, don't miss out on the potential of the fine print here. The bottom line is that the good doctor in New Jersey fought back. Of course, I'm sure the lawsuit was of sufficient magnitude to catch anyone's attention, but the reality is few docs, regardless of specialty, actually fight bad news coming their way. Now, the official term for such a fight back in our defense is called an appeal. And research shows that the math is on your side. Approximately 64% of all appeals win. However, the sad news is that less than 10% of all physicians actually appeal. They don't fight for the right to get paid, and they're probably not putting much of a struggle up to fight for the right to party either. But don't be one of them. If an insurance company wrongs you, fight back. A payer claims that you can't do X, Y, and Z procedures on the same date without a modifier, but you've done them correctly, fight back. Someone denies your care, don't accept their word as gospel. Fight back. Someone demands their money back for services you've already rendered in good faith. Hold on to your wallet and fight back. Yes, even when an insurance misquotes the verification of benefits, fight back. Believe it or not, the law is on your side. There are court cases and successful appeals waged in all the above examples and more. If you don't like writing letters or don't know where to start, consider getting our new edition of our Chiropractic Appeals Toolkit, and it's all done for you. If not, remember, you just have to fight back. This is Dr. Tom Nacelle from Strategic Chiropractor. If you like receiving these video blogs or you like to read a blog, check out our website at strategicdc.com. All right, take care.